I'm J. Jermaine Bay with Lodian Moorish Pradium, Ante, Colorado. The acronym is AMPAC. I'm the Chief Judge of Consular Court. Today is Class 106. Class 106. What do we learn in Class 105? Well, we're starting to learn from the United States international organization about how to interpret treaties, right? So the United States is teaching the Moors how to interpret treaties, and just like Noble Drew Ali said, he said, going to leave the Europeans here long enough to teach us government, right? So the United States is teaching us government. Well, what about government? Well, the United States International Organization is teaching us how to enforce treaties through interpretations of treaties, such as the Charter of the United Nations, 1945. The Charter of the United Nations is a treaty in itself. It is a multilateral treaty, right? And that's what Moors have to understand. Charters, conventions, and declarations are also treaties, right? And recognized in international law as treaties, okay? That must be understood. Any arrangement between two or more states, right? A bilateral contract or a multilateral contract is referred to as a treaty amongst states, okay? So it's how states treat each other. That's why they call treaties, okay? So as the Moors will learn, as you start getting to statehood, all of your treaty instruments will be deposited through a treaty portal with the United Nations. They intentionally call it a treaty portal, because all your documents that are deposited are treaties, right? So what is a treaty? Well, the Charter of the United Nations is a treaty amongst multilateral states, okay? So the United States right now is teaching us how to enforce the Charter of the United Nations of 1945, Chapter 6, right? Which is about the Pacific Settlement Dispute. Because right now the United States is showing us how to write the proper written instruments to the International Court of Justice, right? So we're learning in the case of Ukraine versus Russia of the year 2022 that the United States right now is writing a letter, right? A correspondence letter of declaration of intervention to the registrar of the ICJ. So the United States is showing us the due process, right? The standard operating procedures, right? The standardized operating procedures of how you reach out to the United Nations, right? So what's one of the treaties that they're enforcing? Well, I already told you the Charter of 1945, right? Chapter 6, right now at the ICJ. What other type of treaty are they showing us how to enforce? We're talking about the Convention, right, on the prevention and punishment of crime, the crime of genocide of 1948, right? That's another contract, that's another treaty the United States is teaching us how to enforce. What's another treaty or contract that the United States is teaching the Moors how to enforce? We're teaching us how to enforce the International Court of Justice statutes, right? Remember, we talked about Articles 62 and 63, and what is Articles 62 and 63 about? Well, when you're trying to intervene, right, you want to have a legal nature that gives you the permission to intervene and to come together as erga omnes parties in the class action lawsuit, where the United States said will enforce the statutes of the International Court of Justice of 1946, Articles 62 and 63. We're learning this from the United States, right? We're learning how to utilize these political instruments, right? Because all these treaties are political instruments, okay? What else are we learning? What else is the United States teaching us? They're teaching us how to enforce the Vienna Convention on the Law of Treaties of 1969, Articles 31 and 32, which is about the interpretation of treaties, right? It's called the supplementary work, right? So you got the supplementary work and you got the preparatory work. So it's the preparatory work leading up to the conclusion of a treaty. And then after the treaty's been concluded, now you got the supplementary work afterwards, right? That's the afterwards, after everything's been signed off and concluded, right, by the negotiating states, right? And then after that, the contracting states come in and become a party to said treaty, right? So we're learning how to enforce all of these contracts, Moors, and the United States is doing a good job of showing us how to enforce genocide against another belligerent state, right? But at the end of the day, how is all this possible? How is it that the United States International Organization is able to enforce all these contracts? Well, it's because they have a constitution, right? And through their constitution, they have what's called state. And through the state, they enact bills, and those bills turn into law once they're ratified into law. What type of bills? Well, some of those bills are actually international law instruments, i.e. contracts, right? So the United States of America will say, okay, well, let's go ahead and use a United Nations resolution. Let's go ahead and ratify it through the legislative branch. And through the legislative branch, it's ratified, right? The legislative branch ratifies it, and then they pass it over to the executive branch, and the executive branch signs it into law. Let's say it's the Rights of Indigenous People of 2007. Well, now you use your constitution through your constitutional procedures and your two branches of government, which is the legislative branch and executive branch. They sign it into law, and then you take that, what? You take that international contract and you now deposit it with the United Nations in accordance to Article 102. So now it's been ratified, deposited, and then you bring it back and you promulgate it and you make it public law. And that's the only time that you talk about the Constitution, right? It's only when you have a constitutional procedure to ratify a bill into law. Once you do that, especially you're talking about international law, then you put your Constitution down, right? The United States of America, or should I say the United States International Organization, puts the Constitution down, then they pick up international law. Well, what about international law? Well, it's whatever they ratified, deposited, and promulgated. They put the Constitution down, they pick up the international law contract, i.e. the treaty, right? So that's the same thing the Moors are doing, right? Take, for instance, this is AMPAC's Constitution. Through AMPAC's Constitution, we have three branches of government. Through the three branches of government, we do what? We pass bills into law. All of our bills, such as the Rights of Indigenous People of 2007, is a bill, right? A bill of consideration. It becomes public law once the House legislators, the matriarchs, sign that bill into law through the legislative branch. Then that bill is then passed over to the executive branch, where the head of state, i.e. the wazir, head of state, signs it into law. Once the wazir signs it into law, once the head of state signs it into law, then you can take that international document, right, that instrument, that treaty, and deposit it with who? United Nations, right? Secretary General or the Secretary of Article 102, right, of the Charter. Now, once that happens, now you put your Constitution down, such as AMPAC's Constitution. We put our Constitution down. In fact, we have a dispute, right? So we have a dispute with the United States of America and the United States International Organization, right? If our Moroccan state, our provincial Moroccan state has a problem with the United States of America, you put these two constitutions down, right? And you do what? You pick up international law. But both states have a high probability that both states have already ratified, deposited, and promulgated, right, the treaty, such as the Treaty of Peace and Friendship of 1836, right? So both states have become parties to it. So now they have a dispute. What do? They put their constitutions down, they pick up the treaty. That's how it works. You don't talk about constitutions no more, all right? This is what the United States is teaching us. Now that we've been studying Ukraine versus Russia, how many times have you heard the United States of America or the United States International Organization talk about their constitution? You haven't at all, right? We've already read through at least 15 pages. They haven't mentioned their constitution. They haven't mentioned Ukraine's constitution. The United States hasn't mentioned Russia's constitution. So I say all that to say what? The Moorish Americans have been miseducated. We've been taught to enforce the Constitution. That's a misconcept. And this is why this miseducation has put us in a status of indoctrination. And that indoctrination has kept us in a status of subjugation and oftentimes on the path to what? Incarceration, right? So we got to get out of that, Moors. It's not about the United States of America Constitution. It's about your own Moroccan Constitution and knowing when to put your Constitution down and pick up international law. All right, so speaking of constitutions, as you know, AMPAC study session always opens up the Constitution. The Constitution is paramount, it is first. Without the Constitution, you can't become parties to treaties, right? You always use your Constitution, use your state as a pass-through to get access to treaties. Without the state, you don't have access to treaties. That's the bottom line. That's very important to understand, okay? It's a 1-2 punch. Without the Constitution and the state, there are no treaties. You cannot enforce treaties without a state. That's the bottom line, all right? So either you're a part of a Moroccan state, or you're stateless, or you still come under the protections of a foreign state. And Moorish Americans still come under the protections of a foreign country commonly known as the United States of America. And that's the truth. Let's move on. All right, so right now, as the Moorish know, we're still going over the Charter of the United Nations of 1945. We're in chapter 6. We're still going over Article 33 through 37. Okay, right now, the United States and Ukraine, all of the European states are enforcing Article 36. Okay, so in Article 36, it says, in making recommendations under this article, the Security Council should also take into consideration that the legal disputes should, as a general rule, be referred by the parties to the International Court of Justice in accordance with the provisions of the statute of the court. You see, the statute of the court. So you got both the Charter of the United Nations and its 111 articles, and then you got the statutes of the International Court of Justice and its 70 articles. Two separate contracts, okay? All right, so that's very important. That's what's happening right now with Ukraine versus Russia, okay? That's what we're learning right now, Moors, all right? Okay. So with that being said, we were reading over the Declaration of Intervention that the United States International Organization wrote on behalf of Ukraine, right? So approximately 41 European states became erga omnes parties and wrote a declaration of intervention to support Ukraine, okay, in the Genocide Act that was taking place, all right? So as a recap, we're going to pick it up right here on section 21, so we'll read the title, we'll pick it up from there. All right, go.
The Genocide Convention sets forth the definition of genocide and the contracting parties' obligations with respect to the prevention and punishment of genocide. 21. The Genocide Convention in Article 1 confirms that genocide, whether committed in time of peace or in time of war, is a crime under international law which the contracting parties undertake to prevent and to punish, end of quote. As the court previously has explained, the origins of the convention show that it was the intention of the United Nations to condemn and punish genocide as a crime under international law, involving a denial of the right of existence of entire human groups, a denial which shocks the conscience of mankind and results in great losses to humanity, in which is contrary to moral law and the spirit and aims of the United Nations. The first consequence arising from this conception is that the principles underlying the convention are principles which are recognized by civilized nations as binding on states, even without any conventional obligation. A second consequence is the universal character both of the condemnation of genocide and of the cooperation required in order to liberate mankind from such an odious scourge.
All right, thank you very much. Okay, Moore, so we've gone over this particular paragraph already, okay? They are entering section 21 on page 14 of this particular PDF. The United States has now invoked the Genocide Convention, which is a treaty. A convention is a treaty. So the United States is invoking the Genocide Convention in Article 1, right, to talk about genocide, right? But then it also turns around and talks about the court, right? Talks about the court, and then it starts to quote what the court said, right? So what's happening here? Okay, let's talk about standard operating procedures. All right, because what we're going to learn from the United States is they're utilizing what's called premeditated, right? Prearrangements of contracts in order to seek victory, right? They're on a strict path. They're being very disciplined in their approach, okay? So what's happening, boys? Let's talk about this. Break it down. There's no use in us reading Ukraine versus Russia and not really understand the concept and the context of why we're reading in the first place. Why are we reading Ukraine versus Russia? So we can learn the interpretations of treaty. How do you enforce international law? Okay, well, check this out, boys. What do I have up here on the screen? Okay, this is the basic concept of standard operating procedures on how do you enforce international law. Listen up. Okay, this right here is the 4 pillars of writing international law documents. Okay, this is the same concept the United States is using right now. This is the same concept that Moroccan Moors would use too, all right? Okay, check it out. So I've got 4 boxes, right? 1, 2, 3, 4 boxes, okay? And right here in the center, that's the USA. That's the United States of America, all right? Well, why do I have the United States of America in the middle? It's because the United States of America is surrounded by contracts, okay? I'll get into that, okay? United States of America is in the middle, and now you're starting to flank them, you're flanking them, and you're surrounding them with contracts. Okay, it's just like chess. In chess, you flank pieces, right? You move your pieces in combination, okay? So here's what's happening. The United States is invoking treaties, right? They're invoking treaties. The United States is invoking their constitution because through their constitution, they have to ratify, deposit, and promulgate the treaties such as the Convention on the Prevention and Punishment on the Crime of Genocide of 1948. So through their constitution, they have to ratify, deposit, and promulgate that treaty to make it law in order for them to enforce it now, okay? And then what else? The United States is utilizing the charter, right? The charter provisions of declarations, conventions, and resolutions. So right now, they're talking about the Convention of Genocide, right? That's what they're talking about right now. But all declarations and resolutions are considered international law. So without the charter itself, there will be no declarations through the United Nations. So you can't talk about the rights of indigenous people of 2007 without first recognizing that the charter has full force and power, right? That is full force and effect. Okay, so what's the fourth one? ICJ. So this is what Moors will learn. You'll learn how to enforce the International Court of Justice case laws, right? That's what the United States is doing right now. Let's go back to it. Let's go back to it. So this is their Declaration of Intervention. What did they just invoke? They invoked a convention, Genocide Convention, and then they started to invoke what they said as the court previously has explained. So now they're invoking what the ICJ already said, right? Okay, let's go back to the 4 pillars. So they're invoking treaties, okay? They're invoking treaties, okay? All right, so such as Moors, they invoke the Treaty of Peace and Friendship, right? Treaty of Madrid, Act of Serra. These are all treaties, all right? These are more germane to the Moors, okay? But then the United States is enforcing their constitution as a state. A constitution means you have a state, but the constitution has to be ratified, deposited, and promulgated in accordance to international law in order for it to be recognized as an instrument or a character of international law, okay? So now, once you have your constitution, now you can become parties to treaties. Once you become parties to treaties, now treaties become what? The supreme law of the land. You see how I put the constitution second? And I got treaties first? Well, there would be no treaties without the Constitution. But once you sign a treaty into law, it immediately becomes the supreme law of the land because it's enforcing human rights, okay? So you got treaties, Constitution, then third, utilizing the charter, and then last but not least, you're utilizing the International Court of Justice cases. Now right here, through these cardinal points, right? So I got north, south, right? I got east and west. So you're surrounding the United States of America with a bunch of contracts. That's all this is contracts, more. Treaties are nothing but contracts. And the reality is the United States of America has placed their signature and their ratification and depository on a lot of contracts, and this is what you enforce against them, right? This is the same thing they're doing against Russia in this case. This is the same thing they're doing. They're enforcing contracts to support Ukraine. But they're also letting all the other states know that they are parties to these same contracts as well. Okay, this is what we're learning from the United States. They're teaching us this, okay? So let's take it to the board real quick, all right? Let's take it to the board. What are we learning right now? There's no use in us reading Ukraine versus Russia for no reason without understanding the concepts and context, right? So at the board, we got Charter of the United Nations, Chapter 6, Articles 33 through 37. It's about the Pacific settlement of disputes. How do Moors settle disputes with decolonization, right? How does Ukraine settle a dispute with Russia? How does 41 European states settle a dispute with Russia, right? Okay, here's what's happening. Here's what we're learning right now from the Europeans. The United States International Organization is teaching Moroccans how to decolonize the Empire of Morocco through the enforcement of state rights, treaty interpretations, the competent Consular Court, and the compulsory International Court of Justice by becoming erga omnes parties to a lawsuit, right? That's what we're learning. Because even though we're studying about the International Court of Justice, guess what Moors have to do first according to our own treaties? we have to take everything through where first? Everything must start with the competent consular court first. According to our treaties, all disputes must be settled with the competent consular court first before it ever gets to the International Court of Justice. The International Court of Justice is always second, all right? It must start with your consular court to settle a dispute. After that, then we can petition the ICJ to help us settle the dispute from there, all right? If in fact the colonists are still supervening the impossibility of performance of our consular court orders, all right? Okay, Moorish, so let's go back to the 4 pillars. This is very important for Moorish to understand, okay? And all your international law documents you write, okay, whether it's the Minister of Foreign Affairs, the Consul General, the Consul Court, right, the competent Consul Court, these are the 4 pillars you use in all your documents, okay? We'll talk more about this in the future, but when you do that, the United States of America is in checkmate. They're in checkmate. It's already premeditated checkmate. Why do I say it's premeditated? Because the United States of America signed off all these treaties, and they know in the Treaty of Peace and Friendships of 1787 and 1836, and the Madrid Convention of 1880, and the Act of Algeciras of 1906, the United States of America already knows they're what? Subordinate in that contract. So it's already a premeditated contract that the Moorish governments, i.e. the Moroccans, are superior to the contract, right? And there lies the problem. Moors don't know their own nationality. They haven't been able to enforce the contracts through a Moroccan nationality. They kept saying they were Moorish American, or they kept saying they were Negro, they said they were black, they said they was colored, right? They said they were Pan-African, they said they was African, they said they Hebrew Israelite. They was giving themselves every name but Moroccan. So therefore, if you're not saying you're a Moroccan, right, or trying to return back to Morocco to reclaim your Moroccan birthright, then you can't enforce the treaties, because the treaties are enforceable only by Moroccans. Okay? That's the problem that Moors have had. Let's move on. Okay. All right, so now that we've finished reading section 21, let's move on to section 22. Okay? All right, no.
22. The United States notes that the court has interpreted Article 1, in particular, its undertaking to prevent genocide, to create obligations distinct from those that appear in the subsequent articles of the Convention, which primarily address the punishment of genocide by individuals. This includes, in the court's view, an obligation on contracting parties to employ all means reasonably available to them so as to prevent genocide so far, recognizing that a contracting party may only act within the limits permitted by international law. In this regard, the court has recognized that the notion of due diligence, which calls for an assessment, is of critical importance, and emphasized that a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. Emphasis added.
Emphasis added, that is correct. So that's the United States saying they put emphasis on this, section 22, right? We're going to come back and break down section 22. Let's read section 23 first. We'll come back to section 22.
I'm sorry, 23, Article 2 defines the crime of genocide as any of 5 acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. The United States ratified the convention with inter alia the understanding that the term intent to destroy, or in whole or in part a national, ethnical, racial, or religious group as such, means the specific intent to destroy in whole or in substantial part a national, ethnical, racial, or religious group as such by the act specified in Article 2. And the understanding that acts in the course of armed conflicts committed within the specific intent required by Article 2 are not sufficient to constitute genocide as defined by the convention, emphasis added.
All right, so before we go to section 24, we have to address sections 22 and 23. This is very important for the Moors to understand today. Okay, So what are we learning from the United States, right? Because Noble Drawley said learn from the Europeans. Well, in this particular case, it's about genocide, isn't it?
Yes.
Specifically, right? That's the object and purpose of this particular case, right? So it says in section 22, the United States notes that the court has interpreted Article 1, right? So let's go to Article 1 of that contract, right? Which contract? Well, the Convention on the Prevention and Punishment of the Crime of Genocide, right, of 1948. Okay, so Article 1 says the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and to punish. So genocide is an international law crime, right, between states, so states can intervene to stop genocide, okay? So that's what the United States was trying to point out. Article 1 is more specifically about saying, okay, this contract, the object and purpose of this treaty, of this contract, is all about Article 1. It says the contracting parties. Well, who are contracting parties? The states, right? So the states confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and to punish. Okay, so let's go back to the United States. So section 22, the United States notes that the court has interpreted Article 1. In particular, its undertaking to prevent genocide to create obligations distinct from those that appear in the subsequent articles of the convention, which primarily address the punishment of genocide by individuals. This includes, in the court's view, an obligation on contracting parties to, quote, employ all means to reasonably available to them so as to prevent genocide so far as possible. Let me read that again. It is the obligations on the contracting parties, right? The contracting parties, the contracting states, to employ all means reasonably available to them so as to prevent genocide so far as possible, unquote, or end quote. Recognizing that a contracting party may, quote, may only act within the limits permitted by international law, end quote. In this regard, the court has recognized that, quote, the notion of due diligence, which calls for an assessment of concreto, is of critical importance, end quote. And emphasize that a, quote, a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. Emphasis added. So what does that mean? So sometimes states can already tell in advance that some genocide is about to take place, right? In advance, or that it's already happening in real time, right? So it states the states of planet Earth obligation to intervene when they see acts of genocide, right? But they must have what type of evidence? They must have concrete evidence, see? Concrete. In concreto, right? Which means in real time, right? Real evidence, okay? Proof thereof. Concrete, before states can intervene, right? So it is critical to have the real evidence, okay? So the United States is invoking this because they know they got real evidence of what Russia was doing to Ukraine's territory at the time, right? Okay, now section 23, I'm going to make sense of everything I'm reading, all right? So section 23. Article 2 defines the crime of genocide as any of 5 acts, okay? So let's go back to the contract. Convention on Prevention and Punishment of Crime of Genocide, Article 2. Okay, no?
Article 2. In the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A, killing members of the group. B, causing serious bodily or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D, imposing measures intended to prevent births within the group. E, forcibly transferring children of the group to another group.
Okay, so that's Article 2. Those are the 5 steps that the United States was pointing out, right? So section 23. Article 2 defines the crime of genocide as any of the 5 acts, quote, committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such, end quote. The United States ratified the convention with, inter alia, the understanding that the term, quote, intent to destroy in whole or in part a national, ethnical, racial, or religious group as such, end quote, means, quote, the specific intent to destroy in whole or in substantial part a national, ethnical, racial, or religious group as such by the act specified in Article 2, okay? And the understanding that acts, quote, in the course of armed conflicts committed without the specific, the specific intent required by Article 2 are not sufficient to constitute genocide as defined by the convention, emphasis added. So why did I go back over that again? See, the United States, pay attention, Moors. What is the United States teaching us? That if the Moors want to bring a suit of genocide against the United States of America, we should be quoting Articles 1 and 2, right? Just to start. But you notice what they're talking about. They're talking about in whole or in part. Genocide in whole or in part, right? So in sections 22 and 23, now we need to talk about genocide specifically amongst Moors, right? We're talking about Ukraine versus Russia, but how do we make this germane about Moors, right? Because right now, let's go to the board again. What are the Moors trying to do right now? We're trying to do what? We're trying to decolonize, right? We're trying to decolonize Morocco, the empire of Morocco. We're trying to decolonize. And in the midst of all of that, the United States will still try to use their imperialism, right? Their colonialism, their coercive measures to still try to genocide the Moors to keep them from doing what? And establishing their independent states, right? Now, more specifically, who's really going to try to stop us? Well, it's actually going to be the several union colonial charter states. It's really not the federal government. You're going to get into issues with traffic court. You're going to be dealing with all type of local municipalities, and that's what's going to invoke the Moors to have to constantly keep utilizing international law because you're dealing with local disputes. All politics is local, right? So you're technically not bumping into FBI agents. You're bumping into the local sheriff, and you're bumping into the local police, and you're dealing with localized problems, right? So it's not always the federal government that's giving Moors problems. It's actually one of their 50 charter colonial states that's doing it. From the governor to the mayor, chief of police, on down to the regular police and sheriff. That's who you're having problems with, okay? So we need to talk about genocide. Because this is exactly what the United States is talking about. They're talking about genocide, and they're talking about something needs to be some concrete evidence, right? It needs to be some assessment in concreto is of critical, right? Critical what? Importance and evidence, right? So let's talk about genocide today, Moors, okay? Because that's what we're learning right here. Ukraine versus Russia about genocide, but how do we bring a case of genocide? How do we prove that genocide has taken place in the empire of Morocco? Okay, well, let's talk about that, all right? Now, in the contract, right, commonly known as the Madrid Convention of 1880, all right, the Madrid Convention 1880, I talk about Article 15 all the time, but if we go to the top, let me show the Moors something. How do we come up with concrete evidence, right? How do we start putting together evidence that the Moors have been genocide? Well, the United States is starting to give us the evidence. We're starting to see it, right? Okay, what's the first thing we see that the United States has done potentially regarding genocide? Right here they put in writing, right? In concrete, Moroccan nationality obsolete and without effect. Isn't that an act of genocide? you see that? That's an act of genocide. Right? But wait a minute. Let's go down. Okay, let's go down to now Article 15. Okay, Article 15. Because now we have to understand what's going on. Article 15 gave the Moors a human right, right? A human right through a treaty, a multilateral treaty, to come on back home like Dorothy, right? Did Dorothy have to get permission from the wizard in order to get back home? No, she didn't have to ask the wizard. All she had to do was do what? If you just believe, right? Isn't that what Diana Rossner was singing? If you just believe and click your heels 3 times, right? You just got to believe. Okay, believe in what? Instructions. What did the good witch tell Dorothy? You got to click your heels 3 times, right? Ain't no place like home. Ain't no place like home. Ain't no place like home. You have to repeat what? The words, right? Words turn into sentences. Sentences turn into paragraphs, and paragraphs turn into contracts. They turn into orders, right? So this is what the Moors have to read. You have to click your heels 3 times and read after this and say you want to go back home through a proper written instrument application and return back to Morocco. This is what you call decolonization right here. Article 15 of the Treaty of Madrid of 1880, Article 15, paragraph 1 is a decolonization provision. Okay? But what happened? Well, the United States knew that very well. So what did they do? They said, okay, we got to stop these Moors. How can we stop these Moors? Well, what did they do? They got into what they call a conspiracy, right? They were complicit in doing what? Performing an act of genocide to stop the Moors from having their own nationality. That way they could never go home, right? So here's what happened. Okay, Nova, can you read this?
A U.S. note of March 17, 1959, addressed to the Moroccan Ministry of Foreign Affairs, referred to a note from the ministry dated October 8th of 1958, in which the embassy had been informed that the Moroccan government had decided to strike all prescriptions related to Moroccan nationality from the text of the Madrid Convention. The U.S. note said, in part, the government of the United States of America, having unilaterally relinquished certain rights in Morocco with the reemergence of Morocco into independence in 1956, considers that in line with historical developments of Article 15 of the Madrid Convention on Protection of 1880 has become obsolete and without effect. The government of the United States takes due cognizance, therefore, of the action taken by the Moroccan government as set forth in its above cited note, which the United States government understands to refer only to Article 15 of the Madrid Convention on Protection of 1880.
So what happened here? So the Moroccan government, right? Who was overseeing the Moroccan government in 1958? Huh? That was Mohammed V. Right? So Mohammed V was overseeing the Moroccan government in 1958, right? So Mohammed V turns around and gets into a conspiracy with the government of the United States of America, right, to genocide the Moroccans of the West. Right? These are acts of genocide to do what? Deny the Moorish subjects who are actually Moroccans, Moroccan nationality, to deprive them and omit their nationality. That's an act of genocide. Right? So the United States is saying, well, the Moroccan government sent us a note to the United States of America that said that Moroccan nationality now is what? Obsolete and without effect. Well, wait a minute. Let me ask you more of the question. Listen to me very carefully. How can a Moroccan government say that Moroccan nationality is obsolete and without effect if in fact they still saying that they are still a Moroccan government? Did you catch what I just said? Listen to what I said. I'm going to say it one more time. Very slow. Watch this. How can a Moroccan government say that Moroccan nationality don't exist? That means that the Moroccan government don't exist. Oh, but wait. It's a conspiracy, right? Because the kingdom of Morocco and the Arabs were trying to do what? hijack the Moroccan nationality and keep the Moors from proclaiming that they are the Moroccan nationals. You can't say Moroccan nationality is obsolete and without effect, but yet turn around and say you're a Moroccan government. So that would be what? That would contradict it. I'm going to say it again for the third time. I'm trying to make a point here. That this is how you know that Moors are Moroccans. This is another example of why Moors should know that Moroccans. Listen to this, I'm going to say it again for the third time. How can Mohammed V, who's overseeing a Moroccan government, say that Moroccan nationality is obsolete and without effect? That means that he's saying, the Sultan himself said he's not Moroccan. But see, he ain't talking about him. He's talking about the Moors. The Moors' nationality is Moroccan in the West. But Mohammed V, through a conspiracy, was trying to now say the exclusive Moroccan hereditaments only belong to the Kingdom of Morocco, because the United States of America was desperately trying to keep the Moors from finding out their true nationality, and they needed the Sultan or the king of the Kingdom of Morocco to say through a treaty that the Moors, right? The Moors, let's go back up to Article 15. Who are they talking about in Article 15? Right? They're talking about subjects of Morocco. The subjects of Morocco are Moors, right? You can't spell you can't spell Morocco without saying M-O-R, Moor. The Moors of Morocco are Moroccan. But the Kingdom of Morocco has been conquered by who? Arabs. How do you get Arab out of Morocco? The people are named after the land, and the land is named after the people. So how are Arabs saying they're Moroccans? Well, you know how they're saying it? Because they have a right to call themselves Arabs. But that's okay. They can call themselves Moroccans in Morocco, but guess what? The Kingdom of Morocco is a provincial state government within the Empire of Morocco. The Kingdom of Morocco is a small provincial state within the greater Empire of Morocco. It's just like the United States of America. The United States of America has what? 50 so-called states, union states, 50 of them, under the umbrella of the United States of America, where the Empire of Morocco could have 50 plus provincial Moroccan states within the Empire of Morocco. The United States of America has 50 colonial states within the United States of America. The Empire of Morocco can have 50 states, provincial states within the Empire of Morocco. So the Kingdom of Morocco was trying to say the Moors in the West were no longer Moroccans. Okay, I'm going to go back to it again. Listen to this, Moors. So the Moroccan government in 1958 was trying to say Moroccan nationality was obsolete without effect. Well, that wouldn't make any sense. That means that the Sultan ain't Moroccan, right? So who are they talking about then? They're talking about the Moors, right? Makes sense? Okay, let's go back to an act of genocide. Let's go back to the Genocide Act. All right. Article 2. Isn't this what the United States was pointing out? Article 2. In the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. And here's the 5 qualifications, right? 5 acts. A, killing members of the group. B, causing serious body or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D, imposing measures intended to prevent births within the group. And E, forcibly transferring children of the group to another group. You see, Mohammed V and the United States of America breached all of these, all 5 of them. All 5 of them in 1958 and 1959. Because Muhammad V and the United States of America, Section C, they deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. When they try to say that all the Moors in the West no longer have Moroccan nationality, that's a whole. Now let me tell the Moors something. In 1958 and 1959, right, let's go back to the footnotes that the United States of America put these notes in here. They're telling on themselves.
Yeah.
In 1958, okay, in 1959, okay, the United States population was around 170 million people. So if the United States population was 170 million, that says a round number that 10% of them were Moors, right? That means that 17 million Moors were genocided by the acts of the Sultan of Morocco in 1958, because he petitioned to have Article 15 struck, right? He said he's decided to strike all prescriptions relating to Moroccan nationality from the text of the Madrid Convention. So the Sultan of Morocco, Mohammed V, petitioned to have the Moors' nationality struck from a treaty.
Wow.
And the United States turned around in kind on a conspiracy, right? They became complicit. They turned around and agreed. They say, okay, 1959, they accepted it. So therefore, what happened is 17 million Moors got genocided in the year between the years 1958 and 1959. Okay, let's go back to what the United States was saying about genocide. Let's go back to it. Okay? Now, the United States, in Section 23, let's go to Section 23. It says, Article 2 defines the crime of genocide as any of the 5 acts committed with intent to destroy in whole or in part. So what did the United States do, okay, in whole or in part? To destroy in whole or in part, right? Genocide, the act of genocide is an act to destroy in whole or in part a national ethnical status. So what did the Sultan do? What did the Kingdom of Morocco and the Sultan do, along with the government of the United States of America, do in 1958 and 1959? They tried to genocide, right? Let's go to the Genocide Act. Listen, Article 2 of the Genocide Contract. What did they do? They said what? Let's say Article 2. In the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. So what the United States did, right? What the United States did, and the Sultan, right? Mohammed V, the United States of America, they had intent. That was intent, right? Because they're having correspondence going back and forth to do what? To destroy, right? The whole of all the Moors that was in the West, right? So they deliberately, Section C, they deliberately inflicting on the group of Moors who were Moor subjects at the time, conditions of life calculated to bring about its physical destruction in whole or in part. What's the physical destruction? That taking our nationality, that destroys a whole group of people, right? That destroys a whole group of people, right? That destroys in whole, right? It is destruction of the whole. You see that? That's genocide. So the United States is teaching us how to enforce a case through Consular Court and the International Court of Justice, right, of something they already did to the Moors. They sit here trying to represent Ukraine. They saying that Russia is so bad, but yet The Sultan, who had finally declared independence from France in 1956, now he turns around and he gets into a conspiracy with the United States of America because the Sultan Muhammad V was so interested in commerce and trade that one of the negotiating things was with the government of the United States of America to throw the Moors, Moroccan, the Moors, M-O-R, not A-R-A-B. It's M-O-R, Moor, not A-R-A-B. They threw the Moors under the bus in the act of genocide. So we thank the United States of America for teaching us now how to enforce Article 2, right? We're learning now because Noble Drew Ali said, learn from the Europeans, keep them here to teach you how to run government. That's what we're learning right now. We're learning how to run government, how to enforce treaties, i.e. contracts, right? Now, what do we take away from this, Moors? The United States is teaching us how to use the genocide contract. But let's take a look at another part. You remember it kept saying whole or part, right? Look, whole or in part. What's the part about? Okay, let's learn a little bit more about part. Because we know what whole is. If it was 170 million population in the United States in 1958, 1959, 10% of that 17 million, that's a whole. Okay, let's look at part. Okay, how does the United States determine what a part is? Okay, now we go into section 24. We're learning more. We're learning. Okay, no.
24. The United States understandings are consistent with the court's interpretation of, quote, intent to destroy, end of quote, to mean, quote, a dolus specialis that must be present in addition to the intent required for each of the individual acts involved, end of quote, and interpretation of, quote, in part, end of quote, to mean, quote, a substantial part of the particular group, end of quote. The term substantial part, end of quote, is defined in the legislation that implements United States obligations under the convention to mean a part of a protected group of such numerical significance that the destruction or loss of that part would cause the destruction of the group as a viable entity within the nation of which such group is a part. However, the United States recognizes that the court, in assessing whether the allegedly targeted part of a protected group is substantial in relation to the overall group, has taken into account both the quantitative element and evidence regarding the geographical location and prominence of the allegedly targeted part of the group. Finally, the United States, like the court understands destroy in Article 2 to mean the physical or biological rather than cultural destruction of a national, ethnical, racial, or religious group.
All right, thank you, no. All right, so now the United States is trying to determine what? What is a part of a whole? Was the part, the smaller part of a greater whole of a group, right? They're breaking this down. You see what they're doing? Okay, who should learn how to break this down as well? The United States is breaking it down, and Noble said learn from the Europeans. Guess who else should learn how to break this down? Well, it should be the Moors. How do we now determine, okay, we already know that they've already tried to genocide, or they did genocide the Moors in 1958 and 1959 as a whole. Now let's take a look at what it looks like from a perspective of a part. Fair enough? Okay, watch this, Moors. Okay, from the top. The United States understanding are consistent with the court's interpretation of intent to destroy, to mean a dolus specialis that must be present in addition to the intent required for each of the individual acts involved. An interpretation of, quote, in part, end quote, right? In part, end quote, right? Interpretation of, in part, quote, unquote. You see that? They're making significance to that. First it was whole. Now it's part. I'm going to make sense of this for all the Moors, okay? So it's interpretation. So it's about interpretations of what is in part. I'll say it again. It's about the interpretation of the meaning of what is in part versus what is in whole. All right? So it's interpretation of in part to mean. So the United States is saying it means what? It means a substantial part of the particular group. Okay? The term substantial part, now they're going to define, okay, what does substantial part mean? It is defined in the legislation that implements the United States obligations under the convention to mean a part of a protected group of such numerical significance. Look, Morris. I'm going to come back to this. I'm highlighting these things for a reason. A substantial part is defined, the term is about a such numerical significance. Right? So you're saying this word part, interpretation of part, is about the term, about substantial part, about a such numerical significance. So what's a percentage, right? How many is considered a numerical significance? Okay? Now, I'm going to pause right there. I'm going to pause right there. Now, here's what I want the Moors to remember. See this word right here, in part. In part. Watch this. We're talking part. All right. Now we go back to the Treaty of Madrid, right? 1880. Treaty of Madrid, 1880. You know, I love to talk about Article 15. But look what it says in the footnote. See the word in part. In part. See that? Mm-hmm. Okay. Why did I highlight that? Okay. Let me take it from the top again. Matter of fact, Nova, take it from the top and read all the way to this first paragraph. Just the first paragraph. I'm listening.
A U.S. note of March 17th of 1959 addressed to the Moroccan Ministry of Foreign Affairs referred to a note from the ministry dated October 8th of 1958 in which the embassy had been informed that the Moroccan government had decided to strike all prescriptions related to Moroccan nationality from the text of the Madrid Convention. The U.S. note said, in part, quote, the government of the United States of America, having unilaterally relinquished certain rights in Morocco with the reemergence of Morocco into independence in 1956, considers that in line with historical developments, Article 15 of the Madrid Convention on Protection of 1880 has become obsolete and without effect.
Okay, so the United States turns around and quotes this word, not quoted, but I highlight, they say, in part. Okay, what are they talking about? What happened in part? Okay, so then they give you the answer to the test of that, Morris. What do they mean in part? They say the government of the United States of America having unilaterally relinquished certain rights in Morocco with the reemergence of Morocco into independence in 1956. So this word in part, right, listen. This in part word has something to do with what? It's tied to what? The independence of Morocco in 1956 that caused the Sultan Muhammad V to turn around and do what? Remove the nationality of the Moors. Something happened after 1956. Well, what happened in 1956? Okay. What happened in 1956? You see this right here? Relinquished, right? Relinquished what? Jurisdiction, extraterritorial jurisdiction in 1956. They relinquished, United States of America relinquished in part. They relinquished in part some jurisdiction in 1956. All right, listen. Now we go to the Treaty of Peace and Friendship. This is 1836. I'm going a little backwards now, okay? Because I'm building back up. I'm going backwards, I'm going to build back up. Look what it says in the Treaty of Peace and Friendship. This is how the Moors have to study. No, can you read right here?
Termination in part. Extraterritorial jurisdiction in Morocco relinquished by the United States of October 6th of 1956.
All right. So right here, the United States put in their what they call their constitutional procedures on how they became a contracting party to the Treaty of Peace and Friendship of 1836. But down here they have this footnote. They say termination in part. Termination in part. Extraterritorial jurisdiction in Morocco relinquished by the United States October 6th, 1956. Okay, here's that in part, and they're talking about this 1956 extraterritorial jurisdiction again. Why are they talking about that again? Okay. All right, Morris. Here we go. We're talking about in part. Okay. What is this? We've gone over this before. No, from the top.
United States statutes at large containing the laws and concurrent resolutions enacted during the second session of the 84th Congress of the United States of America of 1956 and proclamations of Volume 70. Public Law 856. Charter 807, page 773 through 774. U.S. Code 22 USC 141 through 143. Statute 8 Stat 484.34 Stat 2905. AA 222141, Department of Justice.
Okay, where's this going? This is Public Law 856.
Right.
Right? And Public Law 856 was a bill passed in 1956. Mm-hmm. Right? So the Moors said, they came down, the Moors read the first title, and they ran off all happy. They read this, it said, approving the relinquishment of the consular jurisdiction of the United States in Morocco. Moors read that first sentence, and they ran off saying, the United States of America don't have jurisdiction over me. They relinquished consular jurisdiction in the United States in Morocco. They said it was approved. Remember what I taught the Moors in previous AMPAC study session classes? I said they hit y'all with the okie doke. Mm-hmm. They fooled you with this title. They said it was approved, but what was approved? What was approved? Okay, listen, Moors. Matter of fact, we're going to read it on down, so we're going to read this, and we're going to get down to the good stuff. Okay. No.
Whereas the laws of the United States invest the ministers and consuls of the United States in certain countries, including Morocco, with judicial authority so far as the exercise of the same is allowed by treaties with such countries and in accordance with usage in such countries, and whereas the consuls of the United States in Morocco are permitted to exercise jurisdiction over American nationals under the treaty between the United States and Morocco, signed September 16th of 1836, and the Act of Algeciras signed April 7th, 1906, and the exercise by custom and usage the same jurisdiction over subjects of Morocco or others who may be designated as proteges under the Convention of Madrid signed July 3rd of 1880, and whereas Morocco is now the only foreign country where the consuls of the United States exercise such jurisdiction, and whereas it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco at such time as it becomes appropriate. Therefore be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled that the relinquishment by the President at such time as he considers this appropriate of the consular jurisdiction of the United States in Morocco is hereby approved, and sections 1693, 4083, and 4091, inclusive of 4097 and 4122, inclusive, and 4125 and 4130, inclusive of the revised statutes as amended, are repealed effective upon the date which the President determines to be appropriate for the relinquishment of such jurisdiction, except so far as may be necessary to dispose of cases then pending in the consular courts in Morocco, approved on August 1st of 1956.
Okay, so what happened here, Morris? This is what you call a bill. This is a bill. This is not law. Moore said, it says public law. 856, it must be public law. No, it's not public law. What was the public law? They give you the answers to the test. They tell you right off the top what is the actual law. They tell you right off the top what is the actual law. They say, whereas the laws of the United States invest the ministers and consuls of the United States in certain countries, including Morocco, with judicial authority so far as the exercise of the same is allowed by treaty. So the treaty, boys, the treaty is what? The law. That's the public law, because treaty is supreme law of the land. You follow me so far? I'm still talking about the word, listen, I'm still talking about this word, what? In part. This is the United States Declaration of Intervention. Remember, we were talking about this word in part. We're defining that now. In part. Let's go back. We're going to Public Law 856. Okay? So what is Public Law 856 enforcement of? It's an enforcement of treaties. Treaty. But this is a bill. Okay, it's a bill. Now listen. So the United States turns around and says, they start putting it in the 1880 Treaty of Madrid, right, in the footnotes. Listen, they put this word in part, right? They said in part there was a relinquishment of 1956 jurisdiction. In part. Okay, then they turn around and say it again, right? I'm going backwards now. 1836 Treaty of Peace and Friendship. They say termination in part. Okay, let me increase the size. They say termination in part. Okay? And they continue to tell you part of what? They say, oh, part of the extraterritorial jurisdiction in Morocco relinquished by the United States October 6, 1956. Well, wait a minute. Either you've relinquished all or not.
Right.
Ain't no such thing as part. So what are they talking about, this part? Okay, now you come back over to Public Law 856. They gave you the answer to the test, but the Moors are like, they relinquished jurisdiction. The United States don't have jurisdiction no more. I say, okay, did the Moors read it? They give you the answer to the test. You go down and they tell you right here, Moors, look at this paragraph right here. No, can you read this paragraph for me one more time, please?
Whereas it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco at such time as it becomes appropriate.
All right, so what did it just tell you, Morris? That what this is that the president, when he got this bill, okay, the bill, he never signed into law. He just made it what? An executive order to be what? A policy. See, a policy is not law. So therefore, when they keep saying in part, what they keep saying when they say in part means what? In part, right? There's in part up there. Then you got in part where else? You got in part in the Treaty of Madrid, 1880 in the footnotes, in part, right? You see it. 1836, United States turned around and said termination in part. What were they trying to tell the Moors? They tried to tell the Moors that they did not pass a law. They passed a policy. Okay, Moors, let me give you another example. Okay. Okay, Moors. What happened? What's my point here off the top? The United States of America has not relinquished jurisdiction in the Empire of Morocco. That's my point. The United States of America and the United States International Organization has not relinquished jurisdiction, extraterritorial jurisdiction over Moorish subjects. That's been naturalized in the United States jurisdiction. Why not? Okay, listen. Here's the United States, right? 3 branches of government of the United States International Organization. What happened? Public Law 856 got passed through the legislative branch. Okay? Through the legislative branch, it got passed. So the House of Representatives and the Senate passed Public Law 856 and passed it to where? They passed it over to the President of the United States, the executive. And what did the president do with it next? You know what he did with it? He sat on it and said, I'm not going to sign it, what? Into law. He said, I'm going to turn it into what? Policy. Policy, Moors. Policy. Policy is not law. It's policy. So every time they keep saying to the Moors said they didn't relinquish jurisdiction. No, they didn't. They only relinquished part of it. Part. It was a part. It says it right there. Moors don't know how to read. I guess they just skim things. I'm not sure. I'm being respectful to the Moors, but look, it's been in front of our faces for decades. Okay? It says termination in part. Extraterritorial jurisdiction in Morocco relinquished by the United States October 6, 1956. In part. Because the public, they haven't relinquished jurisdiction. So what did the Moors have to do? Why did they only do it in part? It's because the Moors were still what? Stateless. Right? So what was the main part of what they did? Okay, the United States got rid of what? They got rid of Consular Court. Right? So in 1956, they got rid of Consular Court. Okay, so who was the president? Right? Who was the president in the year 1956? Well, it was Dwight D. Eisenhower was the president between 1953 and 1961. Okay? So Dwight D. Eisenhower was right in the middle of just about everything. Everything. Okay? So what's happening? So Dwight D. Eisenhower, okay? Dwight D. Eisenhower was instrumental in understanding the negotiations that was taking place with the Kingdom of Morocco, right? Dwight D. Eisenhower was instrumental in genociding the Moors to steal their nationality, along with Muhammad V. Because Muhammad V was looking for independence, so he got greedy. He threw the Moors underneath the bus for his own selfish need, right? Okay, so Dwight D. Eisenhower, from 1953, he relinquished Consular Court 1953 to 1961. So in between those dates, right? In between those dates, what happened? A whole lot happened in these dates, right? What happened in 1952? Well, that was France versus the United States of America, right? So in France versus the United States of America, 1952, the case came out that the United States could keep a limited consular jurisdiction over Moors because Moors were still asleep. They acquiesced, right? Because they run around saying they're Moorish Americans and they're not Americans. So Dwight D. Eisenhower comes into office in 1953, right after the ICJ had ruled in 1952, right? So what happens in 1956? Well, in 1956, what does Dwight D. Eisenhower do? He puts together what? Public Law 856, because that was a mandate from the International Court of Justice said that the Moors can still be what? Come under the jurisdiction of the United States of America, as long as they kept running around saying they were Moorish American instead of saying they were Moroccans and following the instructions of the treaties to return to Morocco through what? Statehood. Moors were still stateless. Okay? So Public Law 856 comes out in what? It comes out when? 1956, right? So going back to Dwight D. Eisenhower, he's instrumental during that time frame, right? But why is it that Public Law 856 came out in August? Okay, Morris, listen to me. All right. What do I have up here? You see, Muhammad V in 1958 and 59 said also Moroccan nationality don't exist. We're going to break this down a little bit today, Morris. We're going to talk about Dwight D. Eisenhower, the United States of America, right, and the Sultan. What do I have up here? This is a timeline of treaties that recognize Moors as Moroccans, okay? So we're going to talk about Dwight D. Eisenhower, right, etc., okay? Even keep in mind J. Edgar Hoover, who was the director over the FBI, came into office in 1924, and he left office in 1972. He actually transitioned in 1972. So from 1924 to 1972, J. Edgar Hoover was overseeing a lot of this stuff we're about to go over, okay? All right. So first of all, let me prove to the Moors that the Moors are Moroccans, and then all of a sudden the Sultan says, we're not Moroccans no more. All right? Okay, here we go. Timeline of treaties that recognize Moors as Moroccans. So first we got Treaty of Peace and Friendship, 1787, recognized Moors as Moroccans. Number 2, the Constitution of the United States of America of 1789 and the Constitution of the United States, 1871, Article 3, Section 2, Clause 1, recognize Moors as subjects and not citizens. So subjects are what? Moors, subjects of Morocco, right? Number 3, Treaty of Peace and Friendship of 1836 recognized Moors as Moroccans. Number 4, Madrid Convention of 1880 recognized Moor subjects as Moroccans. Number 5, Act of Serres of 1906 recognized Moorish governments as Moroccans, right? Number 6, Treaty of Fez of 1912 recognized Moors as Moroccans. Number 7, Noble Drew Ali from 1913 to 1929 recognized Moors as Moroccans. Number 8, the French Protectorate of 1913 to 1956 recognized Moors as Moroccans. Number 9, France versus United States of America, ICJ case of 1952 recognized Moors as Moroccans, right? Number 9, France versus United States of America, ICJ case of 1952 recognized Moors as Moor subjects and proteges, i.e. as Moroccans. Let's read it again. Number 9, France versus United States of America, ICJ case of 1952 recognized Moors as Moorish subjects and proteges, i.e. as Moroccans. Number 10, Muhammad V declares a Declaration of Independence March 2nd, 1956. Now he wants independence. Number 11, United States Public Law 856 of August 1st, 1956, right? Recognized Moors as Moorish subjects and proteges, i.e. as Moroccans. That's Public Law 856. We read it, right? Then all of a sudden, what happens? Okay, number 12, United States Public Law 856, Part Relinquishment Policy of October 6, 1956. Number 13, the Kingdom of Morocco and the United States deliberately agreed to omit Moroccan nationality from the Madrid Convention of 1880, Article 15, in 1958 and 1959. Number 14, in 1959, there were approximately 17 million Moorish subjects under the limited protection of the United States and the Empire of Morocco. 17 million. That was 10% of 170 million people. Number 15, the whole group of approximately 17 million Moorish subjects, i.e. the subjugated Moroccans of the West, suffered deliberate acts of genocide by the Kingdom of Morocco and the United States of America from 1958 to 1959 inter alia, right? Because that's when they put together their correspondence, right? 1958 to 1959, they agreed to strike Moroccan nationality from a treaty. Number 16, the United States of America and the United States have benefited from deliberate acts of genocide against the indigenous Moroccans from 1958 to 2023. A total of 65 years of human rights violations and a breach of the peremptory norms of international law, just cogents inter alia. So as you can see, Moors, how is it when we look at this timeline? How is it we look at this complete timeline? I got 16 line items, right? 16 line items, 16. How is it on every line item it recognizes us as Moroccans? Then all of a sudden now we get all the way to the bottom, and all of a sudden now we become omitted. Right? That's genocide.
Yeah.
This is the evidence that we were Moroccans who were subjugated Moroccans, and all of a sudden now the Kingdom of Morocco, right, turns around and deliberately removes our nationality. Moors got to catch what's happening here, right? So where does the part come in? I've been talking about this part. Well, the part is because the Kingdom of Morocco, okay, let's go back to 1880. You see, in this footnote, they never mentioned technically the word what? Law. These were policies, these were understandings, these were arrangements. But they wasn't technically acts of law. It was because they observed this type of arrangement. So the United States put into place what? Policies. Listen, timeline. Let's go back to the timeline. So that way Moors will understand how Public Law 856 came to be. Okay? The Moors don't even know this information because Moorish American teachers don't teach this. Okay? So France versus United States of America, the ICJ case comes out in 1952 that gave the United States a mandate, right, to relinquish what? Extraterritoriality jurisdiction in Morocco. Yeah. Okay? Once the Moors woke up. But they gave them a limited jurisdiction over Moors because they said, well, somebody got to oversee the treaties. Yeah. Right? So right here it says, Muhammad V declares Declaration of Independence March 2nd, 1952. Then all of a sudden the United States put together Public Law 856 in August 1st, 1956. Right? So look at these dates. What came first? The Sultan declared independence. Right after that, the United States gets into a conspiracy with the Sultan, and on August 1st, all of a sudden now they draft Public Law 856 that said the United States still had jurisdiction over the Moors. But the United States was like, we don't want to just have jurisdiction over the Moors. We don't want Moors to exist at all. Mm-hmm. Okay, so then you come down here, it says United States Public Law 856, Part Relinquishment Policy, October 6th, 1956, they get rid of Consular Court. Okay, they got rid of Consular Court, and what happens next? 2 years later after that, after October 6th, 1956, the Kingdom of Morocco and the United States deliberately agreed to omit Moroccan nationality from the Madrid Convention of 1880, Article 15, in 1958 and 1959. So you see the sequential order what took place? Mm-hmm. That's what you call intent. It was deliberate. They were working on how do we get rid of these Moors. The United States always makes promises to other states. They'll pay them off in order to undermine Moors. They've done it all over planet Earth. And the King of Morocco was very important to them. Why? Because they want the Sultan, just before he enacted his constitution in the year 1962, he wanted the Sultan, the United States of America, wanted the Sultan to turn around in 1958, 1959, just before they enacted their constitution of 1962. The United States said, I want you to come in and omit Article 15. That's an act of genocide, right? That's deliberate genocide. To do what? Okay, let's go back and read. Let's go back and read. Because the United States is talking about Article 2 of the genocide contract, right? All right, Article 2. In the present convention, genocide means any of the following acts committed with the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A, killing members of the group, right? So our good brother, rest in peace, George Floyd, right? Emmett Till, right? Tamir Rice, etc. All our brothers and sisters began what? Killed as a member of what group? Moorish subjects. They're all Moorish subjects. The United States got them listed as black people. But according to treaties, they're Moorish subjects. Right? So when the Sultan came in and struck that provision, it's almost like he said, no, they're not Moroccan nationals anymore. Now they're what? Let's go back to Public Law 856. What is it that the United States wanted? They wanted all the Moors to be what?
American nationals.
American nationals. This is why when Moors say, I'm Moorish American. No, you're not. Moors are not Americans. Moors have been naturalized as being Americans under an adoption agency called naturalization through treaties and constitutions. Moors ain't ever been Americans and never will be Americans. However, if you acquiesce to keep saying you're Moorish American, you tell the whole world you're American, because when you say Moorish American, The last word that says American, that's like when a woman gets married and she hyphenated her name, she just took on the family name of the family she's marrying into. She's taking on a surname. That's called a surname. Moors got to go back to their what? Madam name. What's the madam name? Moroccan. What's the surname? American. This is too easy.
Yeah.
So the Moors have delayed their own justice because the United States has baited the Moors through all the sellouts to tell the Moors that they are American nationals. So the Moors are technically not Americans, they're Moroccans. But they are Americans in part. The Moors are American in part. What do I mean? Because the policies of the United States, the policies still recognize Moors as what? Americans. The 14th Amendment still recognizes Moors as what? Naturalized persons, i.e. who? Black people, Negroes, coloreds, blacks. In part. But the United States of America knows the Moors have a right to human rights. Listen to me, Moors. What happened? So, if the Sultan, listen, what happened? Look at these dates. We're back to the Treaty of Madrid, footnotes, okay? Look at these dates. So, Muhammad V, the Kingdom of Morocco, became a member state of the United Nations in 1956, okay? 2 years before they wrote this arrangement with the United States. So if the Sultan of Morocco, Muhammad V, became a member state in 1956, that means the Sultan of Morocco also understood he was obligated to the Charter of the United Nations, and the Charter of the United Nations is about what? Decolonization, and it's also about what? Human rights, self-determination. So the Sultan Muhammad V was breaching the Charter because he became a member of the Charter and he was obligated to terms and conditions of the Charter. So in 1958, he was breaching the Charter because he became a member state in 1956 and the Charter came out in 1945. Who else was breaching the Charter? So was the United States of America because they signed on to the Charter in 1945. So you fast forward now to 1959, they was committing what? Acts of genocide, right? Because the act of genocide, the Genocide Convention came out when? When did the Genocide Convention come out? 1948. So the Genocide came out in 1948, and here it is, the United States in 1959, and the Muhammad V in 1958, they both knew they were doing what? Genociding Moors. Because they were both members of the United Nations. They both understood the Universal Declaration of Human Rights of 1948. And they both understood the Convention for the Prevention and Punishment of the Crime of Genocide of 1948. So if the Muhammad V and the United States of America was plotting an arrangement to deliberately, in a form of intent, to genocide the Moors in 1958, 1959, that immediately said they have no plausible deniability. They knew the law. They understood international law. All right, listen. So Dwight D. Eisenhower was there right after France versus United States of America came out. He had to enact some policies and some laws dealing with Moors, right? He was also there in 1958 and 1959 when he was signing those arrangements with Muhammad V. He wasn't he?
Yeah.
Right? So when you talk about in whole and in part, you got to understand what's happening. What else is a part? Okay. What else is a part? We're going to come back to Dwight D. Eisenhower in just a moment. What else is a part? Let's go back to Treaty of Madrid. This is very important what I'm about to say to the Moors. Please pay attention. Please pay attention. Well, I'm talking about the word what? Part. Okay, let's go back to the United States because they're teaching us. The United States was talking about this word in part. Let's read this paragraph again. This is very important. I need the Moors to really pay attention to what I'm about to say next. Okay, Nova, section 24 of the Declaration of Interjection of the United States and Ukraine versus Russia, Section 24.
24, the United States understandings are consistent with the court's interpretation of intent to destroy to mean, quote, a dolus specialis that must be present in addition to the intent required for each of the individual acts involved, end of quote. And interpretation of, quote, in part, and end of quote, to mean a substantial part of the particular group, end of quote. The term, quote, substantial part, quote, is defined in the legislation that implements the United States obligations under the convention to mean a part of a protected group of such numerical significance that the destruction or loss of that part would cause the destruction of the group as a viable entity within the nation of which such group is a part. However, the United States recognizes that the court, in assessing whether the alleged targeted part of a protected group is substantial in relation to the overall group, has taken into account both the quantitative element and evidence regarding the geographic location and prominence of the alleged targeted part of the group. Finally, the United States, like the court, understands, quote, destroy, end of quote, in Article 2 to mean the physical or biological rather than cultural destruction of a national, ethnical, racial, or religious group.
All right, thank you very much. No, this is very important right here, what the United States is saying.
Mm-hmm.
Because we as Moors are going to use these same words on the United States for genocide, right? We can bring a lawsuit for what they did in 1959 in part, right? They did it in part, not in whole. They did it in part because in part, what they do, they only passed policies. But what did they do in whole? They struck the Moroccan nationality, okay? But then they enacted what? Policies in part, okay? So you got to understand what's happening here. So what is this about? This is about in part. In part what? A part of a smaller part of a whole. So let's say you only got a part of the Moors. Right now, you only have what? It's only a part of the Moors, right? Part of the Moors. Part of the Moors. Right now, we got 6 Moroccan states. Modern provincial Moroccan states in the Empire of Morocco. That's it. That's recognized states. Now, I want to say congratulations to the other Moors out there, Moroccan nationals who have had their Moroccan public inauguration. I know y'all working with the WRC to go through your steps to be a recognized Moroccan state. So keep up the good work. In the meantime, keep going. We look forward to recognizing you soon. But right now, we've got 6 recognized Moroccan provincial states in the Empire of Morocco, right? But what if the United States tries to do what? What they try to supervene the impossibility of performance of these handful of states, right? Which only have a handful of Moroccan nationals that's trying to enforce what? State rights.
Right.
Okay? So now we go back to the definition. Listen. Now we go back to the definition of what the United States was talking about, right? They was quoting this. Now they're getting specific. They talk about, well, what is a substantial part of a particular group? So now they're trying to define it. They said, well, a substantial part is about interpretation. It's about interpretation. It's about interpretation of a part to mean what? The term substantial part is about what? Such numerical significance. Catch what I'm saying. It's about such numerical significance. So our numerical significance of our Moroccan states, right? Our Moroccan states have a numerical significance. It's only a handful of us in each of the Moroccan states. So therefore, what is the significance, right? The significant number, listen, what is such numerical significance? Well, that can be found in your treaty. Treaty of Madrid already tells you what the numerical significance is. Listen, more, this is very important what I'm about to say. Article 15, paragraph 1 is very specific. It talks in what's called plural. Singular. Singular, right? Not plural, singular. What do I mean? Okay. Article 15, paragraph 1 talks singular. It says, any subject of Morocco, right? Any subject of Morocco. Did it say subjects?
No.
It's singular, isn't it?
Yes.
Which means Moors got to do what? They got to come back what? One at a time, right? You don't come back as a group. You come back one Moor at a time. That's a significant number. One. It takes one Moor to even start the path back to Moroccan nationality. Then that one Moor has to identify what? He's got to identify what? He's got to return. He got to choose. He had that one Moor, that subject of Morocco, the who, right? I taught y'all in the last class, the him and the his, right? Singular, has to choose between the entire submission to the laws of the empire. Well, wait a minute. What about the laws of the empire? You got to come back to what? A government of Morocco. Listen to what I'm saying. I'm going to slow down. So it took one more to have to even come back to even start the process of establishing what? A Moroccan government in the West. One more. However, that one more had to bring on now other subjects of Morocco one at a time, coming back and pledging their allegiance to the provincial Moroccan flag of the empire. Listen to me. How are we ever going to have a Moroccan government if we don't have at least 3 branches of government? So in order to establish 3 branches of government, you need a minimum of what? 3 Moroccan Moors. That creates 3 branches. Isn't that a significant number? That's a significant number. Let's go back to it. The United States said, oh, you got to use interpretation of in part to talk about the term in substantial part in order to come up with such numerical significance. What's the most significant part of a state? The most significant part of a state is what?
3 branches of government.
3 branches of government. In order to establish a state, all these 6 states had to have a minimum of 3 Moors. That's a significant number. But it started with who? 1 Moor. 1 Moor got to come back, right? 1 Moor got to come back. 1 Moor. It says subject. It ain't subjects. It's subject. Singular. So what happens? What is my point? If the United States tries to stop even one Moroccan national, just one Moroccan national of a state, especially if that one Moroccan national is holding one of the branches of the 3 branches of government, then that's a significant number, just one. That's an act of genocide because that is the significant numerical number, right? That's a significant numerical number. That's the such numerical significance, right? Establish the interpretation of in part. So if the United States tries anything to prohibit any one of our nationals to be a part of the state, and they're trying to remove them in part, they took a part of our state, that's an act of genocide. That is the significant number is what? 1. Singular. That's genocide when it comes to what? Our states. Okay, let's go back and look at what the United States said. This is very important. Right here what they said. It says right here in this last sentence, it says, finally, the United States, like the court, understands that destroy, quote unquote, in Article 2 to mean a physical or biological rather than a cultural destruction of a national, ethnical, or racial or religious group. So the United States knows that there's nothing they can do to destroy anything regarding Moroccan provincial states at their varying state of advancement because they ain't nothing but a handful of us in the first place. So the significant number is anything between 1 and whatever. That's a significant number. 1 is singular. Why? Because the treaty Moors, the treaty language says it's all about 1 more. Dorothy was all by herself. It was Dorothy came home by herself. It was only her. Okay? Dorothy. Okay, now listen. This paragraph 1 is the most important paragraph in all of our treaties combined. The Moors right now, we have approximately 166 articles amongst our treaties. 166 articles. Where did I get that number from? Well, the Act of Algeciras has 123 articles. The Treaty of Madrid has 18 articles. The Treaty of Peace and Friendship has 25 articles. That's a 166 articles. And this is the most important article right here out of 166 articles. This is the human rights clause for all the Moors to come back home like Dorothy. This is the portal. Right? This is the portal that the United States is fighting us over. Right? The United States is fighting us over. What's the fight about, Moors? I showed you the slide before. What's the fight about? This is a versus, right? What is it that the Moors are fighting over right now? We're saying we're trying to do what? It's about what? Decolonization and self-determination in the empire. What is it the United States is trying to maintain? They're trying to maintain colonization and naturalization in the empire. That's the fight. Okay? So where can you find this clause in the treaty about decolonization and self-determination in the empire? Where can you find that clause versus this clause that the United States is standing on in a treaty about colonization and naturalization in the empire? That's Treaty of Madrid, right? Let's go back to it. Let's go back to it. This is important. I'm going to hammer this home to the Moors. Paragraph 1, paragraph 2. Paragraph 1 is about what? Decolonization, self-determination, and self-governance. Paragraph 2 is about what? Naturalization and subjugation. Right? So paragraph 1 is all about what? Decolonization, right? Mm-hmm. Paragraph 2 is about what? Naturalization, right? Mm-hmm. Subjugation. This is the whole game right here. This is out of 166 articles between 3 treaties. Treaty of Peace and Friendship, 1836. Treaty of Madrid, 1880. Act of Algeciras, 1906. Out of all those combined treaties, 166 articles, this is the most important one.
Yes.
Going back to the slide. Treaty of Madrid, Article 15, paragraph 1. Treaty of Madrid, Article 15, paragraph 2. Mm-hmm. You see? Mm-hmm. So the Moors have an obligation to do what? We are responsible to come back and make ourselves whole. Mm-hmm. We got to make ourselves whole. Or we always going to remain in part of someone else's family called Americans. In the meantime, we're continuously being genocided. We're basically genociding ourselves. Mm-hmm. We've delayed our own justice, right? Let's get back to Dwight D. Eisenhower. Hopefully the Moors are learning something here today. So Dwight D. Eisenhower was significant during 1953 to 1961, because you know what came out in 1960? Because of what the Sultan was doing and because the African states were decolonizing, guess what came out? Resolution 1514 is about the declaration on the granting of independence to colonial countries and people. This is a decolonization treaty. Right? This is the most important decolonization resolution that ever came out of the United Nations. This came out in 1960. Who was president in 1960? Okay. Who was president in 1960? Dwight D. Eisenhower. He didn't leave office until 1961. So he was affiliated with a lot of what was going on. You see that? Now, sadly, look what happened next. John F. Kennedy takes office, right? He takes office 1961, and he's assassinated 1963. Why Why was John F. Kennedy assassinated? Oh, I'll tell you why. It's because of Public Law 856. He knew he had the power to pen to sign what, Morris? He had the power to pen to sign what, Morris? He could take Public Law 56 from a policy to what? He could take it to actual law. He could make it law. He could make it law for who? He could make it law for all the Moors who were still running around calling themselves Americans. The Moors were still calling themselves American nationals, right? They call themselves American nationals, but he had the power now to bring the Moors back into what? Go from being subjects of Morocco, going subjects of Morocco and proteges of Morocco. He can help them to get back into statehood. Why? Because he knew about Resolution 1514. Because Resolution 1514 came out in 1960. Kennedy came into office in 1961. He knew about Resolution 1514. He knew about Public Law 856. He knew about France versus United States of America 1952. He knew what was up. He was conscious. So they did what? They assassinated him. Then Lyndon Johnson comes into office, right? Etc. Okay? Now, look at this. Quick shout out to the good brother, Barack H. Obama. Why am I giving Barack H. Obama a shout out? Okay. Ignorant black people would tell you Barack H. Obama didn't do nothing for them. But yet they never took the time, the ignorant black people and the Moorish Americans never really took the time to understand that when Barack H. Obama in 2009 went to Cairo, Egypt, you go to YouTube, look up Barack H. Obama in Cairo, Egypt, 2009. He started reading from the Treaty of Tripoli, okay, between who? No, can you read that?
Treaty of Tripoli, Treaty of Peace and Friendship between the United States and the Bey and subjects of Tripoli of Barbary of 1796.
Okay, so it's about Beys in the United States. Okay, now you go down to Article 11, and good brother Obama started reading Article 11 out loud to the world in Cairo, Egypt. He was reading an international treaty out loud. Noah?
Article 11, as the government of the United States of America is not in any sense founded on the Christian religion, as it has in itself no character of enmity against the laws, religion, or tranquility of Muslim, and as the said states never entered into any war or act of hostility against any Mohammedan nation, it is declared by the parties that no pretext arising from religious opinion shall ever produce an interruption of the harmony existing between the two countries. Okay, so
Obama reads this out loud. Everybody's like, huh? What's Obama talking about? Okay, black people. I'm talking to black people and the Moorish Americans who are not Moorish Americans. Moors are not Americans. And Obama was trying to tell the Moors in 2009, good brother Obama was trying to tell the Moors in 2009 that you're not Americans. Let me prove it to you. And I know Moors like reference points. Article 11 of Treaty of Tripoli 1796 that Obama read in 2009 because he got tired of hearing the Moors talking about we Moorish Americans. And Obama's like, oh God, you're not Moorish Americans. So since y'all watching me on TV every day, let me go to Cairo, Egypt, and tell the Moors exactly who they are. So here's what he reads. He says, Article 11, as the government of the United States of America is not in any sense founded on the Christian religion, as it has in itself no character of enmity against the laws, religion, or tranquility of Muslim men, so it's the laws of Muslim men and of the states. So Obama's trying to get the Moors' attention. You need some states in order to talk about laws for Muslim men. And it continues to say, never enter into any war or act of hostility against any Mohammedan nation. So Obama's pointing out what? He's talking about the laws of the Muslim men and the Mohammedan nation. A nation is what? A state. But wait a minute. Why is he choosing this? More like, see, he's trying to show the United States of America is built on Islam. That's not what Obama was trying to show the Moors. It had nothing to do with religion. Obama was trying to point out it's about laws. He's reading a treaty. He wasn't reading the Quran. He wasn't reading the Bible. He wasn't reading the Torah. He was reading a treaty. If he wanted to talk about religion, he would have read a religious text. He read a treaty to get the Moors' attention. He said the Moors is about the laws of states for who? Muslim men and Mohammedans. But wait a minute. Obama, good brother Obama put his political career on the line to show these Moors about Mohammedans and Muslim nation out of state. But wait a minute. Where's Muslim men and Mohammedan found? Oh, it's found in another treaty. Okay, now you go over to the Act Algeciras of 1906. You go to Act Algeciras of 1906, in which the United States is a party, right? You go down to what? You go down to Article 2. You go down to Article 2. Article 2, I'm going to school the Moors today. Moors be talking about religion. It ain't about religion. It's about enforcing treaties. It's about treaty interpretation. The United States said, go back and look at the Vienna Convention on the Law of Treaties. Articles 31 and 32 is about the general understanding of the interpretation of treaties. Watch this. Who are the Muslim men? They're Moroccans. Who are the Muslim men? They're Moroccans. Who are the Mohammedans? They're Moroccans. Who are the Mohammedans? They're Moroccans. Who are the Muslim men? They're Moroccans. Okay, let's go back to the Treaty of Tripoli. Muslim men and Mohammedans. Muslim men and Mohammedans. Muslim men and Mohammedans. Treaty of Act Algeciras, 1906. Muslim men and Mohammedans are what? Moroccans. Moorish means Moroccans. This is what good brother Barack H. Obama was trying to tell these Moorish Americans who call themselves Moorish American scholars. You ain't no scholar. You have delayed our justice, and Obama tried to put his political willpower on the table. 2009. Then he comes back in 2010 and signs what? The Declaration for the Rights of Indigenous People. And the rights of indigenous people have the word state in it 41 times. State. And the Moors keep talking about the Pope. The Pope ain't got nothing to do with your subjugation. It's everything. The enemy is within. The enemy is within the Moors because they suffer from cognitive dissonance. And this man put his political power on the table to wake the Moors up. Black people say, Obama didn't do nothing for us. He did everything for you. He showed y'all about the treaties that says the laws of Muslim and Mohammedans, which is the laws of what? Moroccan states. It's about the laws of the Moroccan states. That's what Obama did. These Moors are stuck on stupid. Excuse my French, I love all the Moors, but we've been hoodwinked, and bamboozled, and led astray by our so-called Moorish American teachers. This is sad, this is shameful, it's a travesty. So as I start to close out, so far we've gotten to section 24. I know we haven't gotten very far, Moors, I do apologize. We've only got to page 15 out of 26. I have to keep stopping because there's no use in reading Ukraine versus Russia because that's not what Moors are interested in. Moors are interested in what's the parallel. What's the parallel of how you enforce genocide against who? A colonist. Right? How do you enforce against a colonist? Let's take it to the board as we start to close out. Right now we're going to Charter of the United Nations of Chapter 6. Articles 33 to 37, Pacific Settlement of Disputes. All right? Today we're reading about what? The United States International Organization is teaching Moroccans how to decolonize the Empire of Morocco through the enforcement of state rights, treaty interpretations, the competent Consular Court, and the compulsory International Court of Justice by becoming erga omnes parties to a lawsuit. So as the Moors know, in the case of Ukraine versus Russia, the United States came together a class action lawsuit to support Ukraine. But the only way the United States of America become a party to that suit, first they had to be what? A state. Then they could become a part of a class action lawsuit of other states. So therefore, our good brother Obama tried to tell the Moors it was all about states for who? The Moroccan nation. I end with that. Islam.